Ji, respected participants, dear teachers, research scholars, legal professionals, and students, I welcome you all to the third day of the three-day webinar session. We are now going. This is the third day of the webinar. We are today going to learn about the basics of the Bharatiya Sakshya Adhiniyam. Now I request Mr. Krishna Shekhar Sharma to introduce our today's guest speaker.
Good evening, myself K.M. Krishna Shekhar Sharma, research scholar from Department of Law, Central University of Karnataka. I take this opportunity to introduce our esteemed resource person of the day, Professor Dr. Y.F. JAYAKUMAR sir. Sir has a rich experience of 35 years into teaching, research and academic administration. He has associated with various prestigious university law schools and national law schools. Sir has pursued Master of Law from Sri Venkateshwara University, Tirupati, and PhD from Osmania University, Hyderabad. Sir was the head department of law of Osmania University from 2008 to 2010. He was also the Dean Faculty of Law, Osmania University, 2012 to 2014. He was also the Dean Faculty of Law, Satavahana University, 2012 to 2017. After 2017, Sir was the Principal of Pendikanti Law College, Hyderabad, from 2017 to 2020. He was also the former Dean Research, Maharashtra National Law University, Aurangabad. He is also the Member Executive Council and Academic Council, Chairman Academic Committee and Board of Studies from April 2022 till date at Maharashtra National Law University, Aurangabad. Sir has more than 20 plus research publications in various national and international journals. Sir's areas of academic and research interest includes constitutional law, family law, alternative dispute resolution, and law of evidence. With this brief introduction about our resource person, sir, I welcome you again to this final day of three-day webinar on new criminal laws. It's our pleasure to host you, sir. Over to Agni.
Thank you, Krishna. Today is the third day of the webinar. For last 2 days, we have learned about the overview of the Bharatiya Nyaya Sanhita, Bharatiya Nagarik Suraksha Sanhita. Today, we are going to learn about the new challenges that we have faced and the reforms that happened in the Evidence Act. From the admissible evidences to proven fact to what the importance of the police confessions are, the oral evidences, how the changes has happened in the Bharatiya Sakshya Adhiniyam. We are going to learn today from our esteemed resource person, Dr. Y.F. JAYAKUMAR sir, about the clarity of the Evidence Act now. Over to you, sir.
Thank you. So please ensure me whether I am audible to you first.
Yes, sir, you're perfectly audible, sir.
So here, because of some rain, then Geo internet has gone. Now I'm just relying upon my mobile phone and not my phone and my neighbor's phone. Okay. So these are the state of affairs when webinar is conducted. So generally, without any contradiction, I say I'm against to all these webinars. So this reason is, I think that even our universities that we do it, there is no any personal interaction. Is it not? But anyhow, when the resources are not there, it is always better. Something is better than nothing. Right. Anyhow, I am very happy that the university, Central University, Gulbarga is doing a wonderful job by organizing a webinar on the new criminal law that recently they brought in. So at the outset, I thank the Dean and the coordinator, and I'm also thankful to the participants to join with me. And I greet the occasion and my wishes to all the participants, because I'm an old man. Okay, right. So the topic today the chosen topic today is Bharatiya Sakshya Adhiniyam 2023. So the participants and those who are actually involved today, they are heterogeneous group. They are from different disciplines and different states and also different places of learning. Now, keeping these backgrounds of the target group, let me confine my presentation is only on the basic facets of the topic rather than go into the issues, intricacies, and challenges. So this is, I think your expectation is also that to look into the basic aspects of the present topic, that is on Bharatiya Sakshya Adhiniyam 2023, that is BSA. It is an overview. So before we examine the salient features or the basic aspects of Bharatiya Sakshya Adhiniyam, I want to share few things, what we call introductory aspects of the Indian Evidence Act and also Bharatiya Sakshya Adhiniyam. See, the Indian Evidence Act, now we are calling it as Bharatiya Sakshya Adhiniyam 2023. It is, this is the law that governs the facts of inquiry. So this point we have to keep in our minds. So this is the law that governs the facts of inquiry. Similarly, this is also the law that governs the facts of admissibility. And if you go to the further, that is, this is also a law that governs the facts of relevancy and examination of what we can say witnesses. And finally, this is also the law that governs the facts of what we can say the proof, facts of proof. So therefore, whenever I am there in the class, in the very first class, I give one SMS message, a short message, formula to the students. What is that formula? To understand the intricacies of the Indian Evidence Act is RAE is equal to P. This is the formula that I advocate. So if you go through the entire Indian Evidence Act, or if you go through the entire Bharatiya Sakshya Adhiniyam 2023, the outcome is only this. What is this is called RAE is equal to P. So what this R stands for relevancy, A stands for admissibility, E stands for examination, and the result is the proof. What is the proof? Is proof of facts, relevancy of facts, admissibility of facts, examination of facts, and ultimately what we get is what is called proof of facts. So this is the purpose of the legislation. So this is not a substantive legislation, that is a substantive legislation. It is only a procedural law. Of course, here and there we can find some substantive provisions. It's not a substantive law. Basically it's a procedural law, but we have few what we call areas where the substantive provisions are also there. Right. So now, at present, we have the Indian Evidence Act. Even today, we are governed by Indian Evidence Act 1872. Right. So there are the so what is this purpose of Indian Evidence Act is to help the courts to determine the existence or non-existence of facts in inquiry. So this is the basic tenet of the Act, to what we call to determine the existence or non-existence of the facts or facts issue in a case. Or this Act has undergone certain changes. I am not using the word major changes. So if anybody says that there are major changes, that is, I am against it. There are certain changes. They are not substantive changes, but there are certain basic changes that are some important changes they have undergone. Right from 1872 to present, that is called 1872 to, that is 2023. So first we'll focus upon what are those changes. Then, so the major change that is what we can say literature change. Well, I call it as a literal change or grammatical change, that what is called in the year 2023, that is Bharatiya Sakshya Adhiniyam. So if you go through the Indian evidence, there is Bharatiya Sakshya Adhiniyam 2023, and where you cannot find any structural or functional or not normative changes in the act. So this is a very clear, that is as a senior teacher, after going through the act of this 2023, my opinion is there is no any structural change, there is no any functional change, there is no any normative change, but change is there. The first change is the title itself. First change is the title itself. What is the title is? Bharatiya Sakshya Adhiniyam, that is 2023. Then after that, if you investigate, if you go into the substantive part of the acts, that where you can find few changes here and there, that those things I noted, and I want to place those things before you as a salient features of the present legislation, that is 2023. Friends, my dear friends, before we look into the salient features or the substantive, or what we can say certain functional changes that they are made in the Act of 2023, I would like to I want to draw your attention on the objectives and the reasons for enactment of the Act of 2023. Put into a different way, after a careful reading of the Act of 2023, so there is Adhiniyam, that is, I understood what are the aims and objectives with objectives. So as per my knowledge is concerned, there are 10 reasons are there. There are 10 reasons for enactment of this new legislation. So this is the first reason is, just if you want to note down, we go to the first slide, my dear friends. First reason is to replace, rationalize, restructure, and modernize the colonial law that is there in India. So that is, what is the colonial law? 1872 law is a colonial law, that is a British law. That we want our own law, that would be the purpose of the governments. Our own law, that is just by putting the name, that's the title, Bharatiya Sakshya Adhiniyam, then we are owning it is our law. That is replace, restructure, rationalize, and modernize the colonial law in India, or the colonial laws. I am using the plural here because IPC is there, CRPC is there, but this is one of the laws here. And the second important objective of this, or the reason for enactment of this legislation, the modern and contemporary issues and challenges with respect to admissibility of evidence. I already told you, the very purpose of the Indian Evidence Act is to examine the existence or non-existence of facts in the court of law. That is the purpose. It is a game. For a game, there are certain rules and regulations are there. So rules and regulations are there that we have to follow. And the third is to provide general principles and rules of evidence, general principles and rules of evidence to ensure fair justice. So what are the objectives in the objectives clause? It is mentioned fair justice we have to provide by using this new law. And fourthly, that is the fourth objective or the fourth reason for enactment of this legislation is to meet the technological advancements. So we have the technological advancements are there, e-documents are there, what we call this content is there. So now what is happening, that you are sitting somewhere and listening to me. Earlier this practice was not there. Eye contact. I used to keep every student. There are 222 participants are already joined, but I don't have any eye contact with you. But here, so everybody is seeing me, everybody is listening to me. That is what we can say. Technological advancement have come in this country to meet those challenges, particularly in admissibility of evidence, what we can say examination of facts and admissibility of evidence. What is the fifth objective is to meet the corresponding changes already done are proposed, corresponding changes already proposed in BNS, BNSS. What that BNS already you told that the Bharatiya Nyaya Samhita, that is IPC. In IPC, there are certain changes are made already. I think that the day before yesterday that we have discussed it. And Bharatiya Nagar Suraksha Samhita, this is the CRPC. So whatever the changes are made in CRPC, whatever the changes are made in IPC, so to meet those changes, what we can say, these changes are made in Bharatiya Sakshya Adhiniyam. These are the 5 objectives. Then I add 5 more objectives. So after a careful reading of the literature is that, so this will help, this Bharatiya Sakshya Adhiniyam will help us to assist operational dynamics of the substantive law and procedure law in finding facts and facts in issues. So the very purpose is find the fact in issues, make it relevant, and examine it, and ultimately prove the existence or non-existence of facts. Then the seventhly, that is the 7th objective of this legislation is to expand the scope of admissibility of electronic and digital records. So this is electronic and digital records has given a very important place in this legislation. I think that is also copied from the previous legislation. So I think there is nothing is new, even in the case of electronic evidence. So this is to expand the scope and admissibility of electronic and digital records as evidence on par with the other records. So whatever the primary evidence that we have, whatever the secondary evidence we have in the form of book or chart or plan or map. So this is what we call the same thing where there is an electronic evidence. On this electronic evidence that we take into consideration, and this is one of the important aspects. Then eighthly, to expand the scope of secondary evidence. So here is predominance is given to the secondary evidence when we compare with the earlier the acts. So this is also that we'll examine, or maybe the salient features we can explain to you. Then the 9th important aspect is to permit or allow the appearances of the claimants. So appearance in the court of law. Please, appearance means appearance in the court of law. And who are those people are? The claimants can appear, accused can appear, experts can appear, witnesses can appear, and victims can appear by what? By what? Appear physically? Appear?
By video conference.
That is what the Central University is doing. Central University is doing. So here is the technology. I am talking about the civil cases, not in all criminal cases. Only in civil cases where the witness can be seen, witnesses can appear before the court of law, experts can appear before the court of law, or victims can appear before the court of law through electronic means. This is one of the radical what we can. I'm not using the word radical changes because the act is already there. Information and Technology Act 2000 is there. 2000 Information Technology Act 2000 is there. So therefore, this is another reason, another objective of this legislation. Last but not least, to put the limitations on the fact, relevancy, and admissibility. So the limitations that we are putting it. You can't bring the entire universe. Whatever the facts available in the universe, you can't bring it. We have to put the limitations. Then only that's called we can get the correct, what we can say, information. Then only we can go to the correct interpretation. Then only we go to the correct application of the facts, and then only we'll get the result, what is called as a proof. So, my dear friends, these are the what we can say the objectives of the present governments to propose this legislation. This legislation is not at all implemented. We are waiting for the notification. Once the notification is issued, and from that date only it will be applicable. But whereas in the central universities or central institutions, the government has given a directive, or it has given directions that this legislation should be discussed with the participants or with the target groups, and what we say the the target group, maybe in the universities or maybe in the institutions of public prosecutions, etc. So this wide publicity should be given. So with this reason, I think that what we call the Central University Gulbarga has conducted this webinar program. So these are the 10 objectives that I identified after careful reading of the literature available, and also these what we call the BEAR Act. So that is the proposed BEAR Act that I have seen. Now, let us go to how the old wine is brought into the new bottle. This is what the students have to examine. So the student, as I already told you, the student is a not homogeneous group. It is a heterogeneous group. Some people are there in the learning stage. Some people are there in the social sciences. Some people are non-law students are there. So for your convenience sake, I draw your attention how this old wine, that is 1872, is brought into the new bottle, that is 2023. So this is a clear statement without any contradiction. Brought into the new bottle. So that is much ado, but not for students. We need what we call the research. See, it's from 82 to 2023. So that is number of amendments were brought to the Indian Evidence Act 1872. Number of evidence. So the major amendments to the Indian Evidence Act was brought in the year 1983 as a result of the famous Mathuras case. That was earlier also a few amendments were there, but they were not major amendments. Only what we call grammatical or structural, functional changes. Nor was brought into the 1872. That is Indian Evidence Act was law within brackets. The next slide. Criminal Law Amendment Act 18. Amendment Act 1983. What is this Mathuras case? How many are Mathuras? Mathura. State of Maharashtra versus Tukaram. The students of law evidence, they know it very well. Where a girl, a tribal girl, went to the police station at the sunset to give a complaint along with the parents. After the constable and the head constable, that's the police personnel in that police station, they said, you the parents and you the relatives, you go away. We want to, what we can say, put certain questions to this. Then the parents were away from the police station. They are staying or they are sitting nearby the police station. So it's also call and is that what this is a passive submission of an innocent girl. Passive submission of innocent girl, and it was a passive submission, it's not a consent. A wonderful interpretation was made. So a interpretation was done by this Maharashtra High Court. But when it went to the Supreme Court, that is what we call grammatical interpreted and categorically said this is where the prosecution failed to that it is a are there under section 375 and read with 376. So therefore, those ingredients are not fulfilling. That is why benefit of doubt is given to the accused person, where the accused person was left free. So Tukaram and his friend. Now there was a hue and cry from the public, and also the representations were given to the Supreme Court. And finally, and after the result of this, what we call the public opinion and what we call, say, NGOs protest, and the year 1983, an amendment was brought into the Indian Evidence Act. That is, section 114A was added. You please read, my dear friends, 114A. 114A speaks about what we call shall presume. So, in case of absence of consent in a custodial rape cases, the custody of the police, where the rape was committed in the custody of rape was against the pregnant woman. In such a case, the burden of proof lies on the accused person. Shall draw an inference unless until it is disproved. So here earlier, what is the general? The criminal law principle on whom the prosecution accused person is innocent till it is has to be established, till the what we call the fact has to be established. But here it's a burden of proof is lies on the accused. The court shall draw an inference. It's not the may. The inference that where the prima facie case is established that there is a rape case, and particularly also workplaces and gang rape or pregnant women, on all these cases, this is called, a title was given, custodial rape cases. This was a very important change in the Indian Evidence Act. Now you see the same language is used in 120, Sakshya, Adhiniyam as it is. So now, whatever it was done in the 1983, that was replaced. Earlier it was 114A. Now it is section 120 of the Bharatiya Sakshya Adhiniyam. This is number one. That is the old wine in the new bottle. The second one is, second important change, Dowry Prohibition Act 1961. So as a result of Dowry Prohibition Act 1961, there are two important provisions were added to the Indian 72. Two provisions were added. What are those two provisions? One is section 113A, another one is 113B. As what we call presumptions as to abatement of suicides, where the suicide was committed by a married woman within 7 years. This is a main presumptions as to abatement of suicides. So that is married women within 7 years of age. This is a may presume. So court may presume or may not presume, depending upon the gravity of the situation, depending upon what we call the circumstances, court may. Once the inference is drawn, it is the duty of the opposite party to disprove the presumption. So here is the may presume. When it comes to section 113B of the Indian Evidence Act 1872, so this is nothing but where there is a dowry death, where there was a demand of dowry death, or the prima facie accused persons are the husband or her relatives, close relatives, and the court, after a prima facie case is established, it shall draw an inference that is called shall presume, and once the shall presume is drawn, and it may be it should be disproved with the help of other evidences, but the burden of proof lies on the other party. So this is these 113A and 113B are reflecting, that is 117 and section 118. Section 117 and 118. So earlier I already given that is 120, that is section 114A, 120 is there. Now 117 and 118. That is another what we call bottle that they prepared and wine was done. That's what we call new wine. So old wine is the new bottle. Then next one is very, very important is that, of course, we deliver a separate lecture on that. That is Information and Technology Act 2000. So that is as a result of Information and Technology Act 2000, and section 65A and 65B were added for admissibility, for relevancy and admissibility of electronic evidence. So this is electronic evidence. So 65A and 65B. Now those 65A and 65B are reflecting in section 61, 62, and 6. So now 61, 62, and 63 are there. These are the three provisions. As it is, whatever the language there in the 65A and 65B previously, that is Indian Evidence Act, the same language, the small modifications, please understand, small modifications, as it is reproduced in B section 61, 62, and 63 of what is that called Bharatiya Sakshya Adhiniyam. This is also another important what we call aspect that we discuss when we are talking about the new legislation, the proposed new legislation. Then next one is Indian Evidence Act, within brackets amendments. 2022 was done. 2020 was done. 1 minute. Am I audible to you?
Yes, sir.
Yes, sir.
All right.
Please
right,
continue. Please continue, sir.
Something is disturbing some issues. Okay, the next is Indian Evidence Act, within brackets Amendment Act 2002, where a provision was added to section 146 clause 3. What is this 146? 146 speaks about what we can say the shaking the credit of witnesses. So where the victim is there, the witness box, that what we call, so when we are examining the character, that what way it can be shaken. So the victim's general and immoral character, there's a provision speaks out, the general and immoral character cannot be questioned here, and the previous sexual experience also cannot be questioned in the court of law. So this is where in the form of cross-examination. This is what 2002, that is what we call the privacy is given to the women. You know that there is a case, a very important case, State of Maharashtra versus Madhukar Narayana. State of Maharashtra versus Madhukar Narayana. You go to the next slide where you can see State of Maharashtra versus Madhukar Narayana. And in this case, what the Supreme Court categorically said was that a women of students of constitutional law, they know it. The students of women in the law, they know it. So what it says is, what it is categorically, that a women of easy virtue has a right of human dignity. So just because she is a prostitute, and a character, easy character, or what we can prostitution, you cannot put whatever the
Hello.
We lost Ragni.
by a okay.
Yes, sir. Yes, sir.
Wait.
Yes,
For
sir,
you.
no problem.
This is a state of affairs. Now we are going to general elections. Okay. Right. I think that my shadow, you can see my shadow, right?
It is
What
good,
about
sir.
voice?
Yes, sir. Please
We can see
continue.
you properly.
Hello.
It is also good.
Yes, sir.
Okay.
Please continue, sir.
Right. Okay. Now, in continuation of our presentation, just I draw your attention. The three, where the section 53A was the further 53A of the Indian Evidence Act further
Sir, your
amended.
voice is not clear, sir. Please, sir.
Hello? Now the power has come.
Yes, sir, it is good now, sir.
Now I am able to talk
Yes, sir.
during this 1 hour. Your side.
Sir, the voice is
Okay.
breaking, sir. The voice is
Yes.
breaking.
I think that is an internet issue, I think.
Now the power has come. That is why I have the internet with the in the phone, mobile. No, mobile data. Yes. Mobile data is there. So problem is, hello.
It is good, sir. You may continue, sir. It is good now.
It takes 1 minute to. Right. Okay. Now, what we have discussed is what are the important aims and objectives of the legislation. How legislation has or normative changes through the Indian Evidence Act 1872 and how those provisions were incorporated into the present law, that is what is called 2023. This is what we say the persons who are well learned and those who are having some familiarity with the Indian Evidence Act, they can understand. Now the people who are not at all what we call connected to our subjects and they are social science students are there and those first year students are there where the law of evidence was not taught. For those people, 10 to 15 minutes presentation will be there and I'll go to this, then I'll go to the interaction. So this is nothing but the salient features of the BSA 2023. Salient features. Suppose in the examination, a short question is asked. So what are the important changes that they have brought into the Act of 2023? And this is that is known as Bharatiya, Sakshya, Adhiniyam. Then anybody can write these things. There are 10 points are there. And those 10 points that just I want to explain to you, my dear friends, in a simple way with a coherence. The first one, you can write without any contradiction. The Indian Evidence Act is completely replaced. Please understand, completely replaced with a title as Bharatiya Sakshya Adhiniyam 2023, but changes, or what we can say, 90% of the previous provisions, 95% of the previous provisions were retained as it is. This is the first act is completely replaced, applicable to all proceedings, including court-martial proceedings under the Army Act, Navy Act, Air Force Act, but not to the affidavits and arbitration proceedings. So this is the second observation. First observation is, so that is the old act as it is retained. So only 5% changes where we can see. And the second observation is, the act is applicable to all proceedings, including court-martial proceedings. They are court-martial proceedings, that is called Army Act, Navy Act, Air Force Act, but not to the thing to do with the uh, uh, CPC and the Indian Evidence Act. Same time, so this
The third important feature, all definitions were brought into section 2 of the Indian Evidence Act. All definitions. So all salient features, first slide. Earlier, the definitions and interpretation clause was there under section 3 of the Indian Evidence Act. Please understand, section 2 was vacant. It was a repealed provision. It was vacant during the British period, something that we did it. So it was kept vacant. Now, all the definitions. So what is a court, what is a fact, what is a fact issue, what is a relevancy, all these interpretations clauses were brought into section 2 instead of section 3. Earlier students used to go to section 3 for interpretation clause. If they want any meaning, they want any definition, they go to section 3. Now you have to come to section 2. This is, I think it's not a normative change. It's only a functional change. Functionally, there is a change. So this is, or we can call it structurally, there is a change. What is the change is? So instead of section 3, come to the section. Important definition, special focus that we have to make evidence and the definition of documents. You please go through these new provision and read it. What is the definition of evidence and what is the definition of document? So the definition of evidence includes electronic, digital documents, earlier different form. So now what we say clearly, conspicuously, it is mentioned electronic and digital documents are also documents within the meaning of the word document. What is the document? That what we used to discuss is anything is expressed or described on any substance purpose of recording. So anything is expressed or described on what they describe on any substance for the purpose of recording by way of letters, figures, or by lithography, whatever it may be. So the same document, whatever that we are having, promissory note, mortgage deed, all these things, whatever the deeds are there, the same electronic deed is also given the same importance. This important observation that I would like to draw your attention as far as the Act of 2023 is concerned. Then document, that is also digital documents, digital records that we have to make it. That is why in the illustration, it's given example as electronic records like emails, server logs, documents on the computers, laptops, smartphones, messages, websites, and the locational or like evidences and voicemail messages stored in digital devices or documents. So this is an explanation given so that it's very clear, no ambiguity. What is a document? Previously, we used to. What is a document? The clear illustration is given. It's only illustrative, but not exhaustive. So from time to time, where the changes may take observation 23. That's where I like this area particularly. Presumption, presume, shall presume, and conclusive proof. But all these presumptions were defined under section 4 of the Indian Evidence. So those presumptions were also brought to the in the modern law. It's not way
Excuse me, sir.
arranged that we have to where we have to search. Next observation is that relevancy of facts. This is the heart and soul of the Indian Evidence Act, my dear friends. Please repeat the presumptions since. Okay. So one of our participants is asked, that is, repeat my observations on presumptions. My dear friend, previously, the important 3 presumptions under the Indian Evidence Act, they were incorporated in Section 4 of the Act, Indian Evidence Act 1872. Now, Section 4 is these may presume, shall presume, and they are also incorporated under the head definition clauses, or what we call say interpretation clauses. Interpretation clauses. Okay, so this is so now you need not Section 4. So 4 is replaced. Now where you can find Section 2 itself. Another observation is relevancy of facts. Previously, there was a chapter under the Indian Evidence Act that was known as chapter 2, and Section 5 to 55 of the Indian Evidence Act speaks about relevancy of facts. In the entire Indian Evidence Act, my dear friends, if anybody say which is important, and any law student can say without any contradiction, that is a 5 to 55. That is the heart and soul of the Indian Evidence Act. If a person is a mastery against the mastery over the Indian Evidence, that is a 5 to 55, I think that it is easy to the student to interpret what the Evidence Act is. So this was very, very important. The parts, almost all the teachers will emphasize how to interpret it. So what it speaks is how to get the facts relevant to the fact of the issue. How to get the facts to relevant to the other facts. This is the game. This is what we can say the game, the rules of the game. The judge shall observe, a neutral observer, that he will observe that how the rules of the game that he has to follow. So there is it is a contesting case. One party is the one side, that is called a plaintiff. The side is there. Those parties, they invoke the provisions of the Indian Evidence Act 5 to 55. They say, sir, it is relevant under Section 10, relevant under Section 12. Now it is the judge to apply his mind whether they are relevant or not. So if they are relevant or not, it has to be examined. This is a very 27 is there. It is already written. From Section 350, these relevant facts are there. Now, students of this new law, what we call it as Bharatiya, Sakshya, Adhiniyam, that you have to concentrate on the interpretation of the provisions from Section 3 to 15, how this is very important. And this is another observation. Another observation where it is not there in my PowerPoint presentation, just to add it. Another observation is, previously admissions were there from admissions. That is the rules of admissions, how to get the evidences. Admission team to 17, from Section 17 to 31 is there. Now it is replaced from 15 to 27. 15 to 27. There is a small change. They are all what we can say structural changes, normative change. Now the complete law has changed. Complete new law is given. So they are all normative changes. If you read that language and this language, the language is the same. Maybe sometimes where the grammatical changes that they made it. So that is even grammar also that they have not, because it was done by what we call Stefan. He is a scholar, or what we call a jurist that he had done it. So therefore, and our people have not done even the grammatical changes also. So it is only structural new Evidence Act.
Sir, if it is possible, can you exit and rejoin?
I want. Okay.
There is some
So you want to
some network issue at your end. I guess.
Jyoti? Yeah. Now is it okay?
Yes, sir. Yes, sir.
Is it okay? Right. Thank you. Thank
Now
you.
it is good. Sir.
So I'm almost we are coming to the conclusion. Right. I think we have only few slides are there. Then after that we close it and then we go further. See, another important observation is structural functional changes here and there they made. Structural changes. What is the structure? What do you mean by structure? Instead of section 3, they made it as a 2. It is a structural change. Functional changes, they made it in some way. But the normative changes, what do you mean normative changes? Completely rewriting the law. So completely rewriting the law is not happened in the present legislation. This is my observation and my submission. Okay? Then another observation is confessions now specially incorporated in section 22, 23 and 24. Section 22, 23, 24 of the new legislation 22, 23. So the old legislation that you forget about that is also structural changes. And the expert's opinion, what is that expert? Who is an expert? Could you respond to me? Who is an expert?
Special knowledge or any.
Right. Okay. Right. All right. Previously, section 45 speaks about. Okay. Right. Just section 45. 45 of the Indian Evidence Act speaks that a person is an expert who is a specialist skilled in foreign law, art or science or identity of handwriting and finger impressions. This was so a specialist skilled in foreign law, art or science or identity of handwriting and finger impressions. So specially skilled in science is sufficient. The other things need not be. So everything will come under the science. So therefore that interpretation that we make it. So we have two provisions previously, that is 45 and 46. And those two provisions now incorporated into one provision that is called structural change. And it's called functional change. So that is under section 39(1), 39 within brackets 1 and 39 clause 2. So this is who is an expert and who is how the relevancy of expert's opinion, and also if there is any contradiction. Section 39 clause 2 speaks about the contradiction. Suppose one expert says that is a particular person is died because of the administering the poison. Other person says, no, it is not a poison. It is only what we call very delicious food, so that he may not die with that what we call that bottle of liquid. So where the contradiction is there between two experts, and that will be referred. Now we have the two provisions are there, the contradictory provisions are there. Section 39 within brackets clause 1 and section 39 clause 2. Then another important is called a judicial notice. What is this judicial notice? So in section 51, 52 and 53, what they did was certain words were there that is unnecessary words. This is a very, very important. This is what the real Bharatiya Sakshya Adhiniyam. What is the one of the objectives of the Bharatiya Sakshya Adhiniyam is? But the first objective that I explained to you is that restructure, replace, rationalize, restructure and modernize the colonial law. That was the one of the objectives. So it is done here. What that is called, for example, certain facts are not at all relevant to the modern day. What is the facts are? UK laws of the Parliament, court proceedings of the United Kingdom, and official seal, authenticity of the official seals of the United Kingdom, and signature manual of the United Kingdom. In what way they are relevant?
So when I was a teacher in the university, National Law University, other universities, every year some students they used to put questions, sir. So in what way they are relevant to us? Then we used to say they are dead letters in the Indian Evidence Act. You don't concentrate on that. But however, it is there in the syllabus that you have to read it. Tomorrow, whenever there is any question on what we can say, judicial notice and other relevant matters, then you have to identify. The court shall take note of all laws in force in the territory of United Kingdom, all court proceedings of the United Kingdom, all official seals of the United Kingdom, all the sign manuals of the United Kingdom. So that is there, but it is up to the court, up to the Supreme Court and High Court that call to take to give any interpretation on that areas. So this is what we can say. Some of the changes that they made, they are deleted. Now they are deleted. There is no UK law. There is no UK Parliament law. There is no court proceedings of United Kingdom. There is no official seals of the United Kingdom. All these things, they are useless and they are removed. That extent, okay, I agree. This is a change. Then next observation is that similarly, there are certain words were deleted, certain examples were deleted in the respective provisions of the Indian Evidence Act. For example, London Gazette and the genuineness of the London Gazette, presumptions as to documents in the England, cessation of territory, power of jury to put questions. Where is the jury now? Long back it is dead. So therefore, those words are also removed. This is even the 1872 legislation also, and they are all negligible. They are what we call nobody cares. Nobody is caring those what we call those words. But now they are officially and with an authenticity that what we call authority, they are removed. So those illustrations, London Gazettes, the presumptions as to documents in England.
Sir, your voice is not audible.
Please. Okay, we'll wait few minutes. Now I think it is sure. I think now, yes. Okay, very good. Next time you call me to Gulbarga on my own, what we can say, TA and DA will come and deliver lecture. This is horrible for me. I think really, I had tension because 250 students were waiting throughout India, different places. But I stood before this small computer or what we call small phone, and I'm unable to deliver my goods up to the mark. This is my feeling. Really, the coordinator and the dean, I am expressing my what we call sorry state, because it's a vis major. It's not in my hands. So I have 3 computers are there in front of me. Everybody is trying to get to connect to this or that, but ultimately that I have chosen this. What is this phone is? It's the Apple phone is there. I think at least this Apple phone will help us. So just like an Apple, right? We are come to the closure, and the one we say certain nomenclatures. They are all nomenclatures. That is a barrister, vakil, attorney, pleaders. They are all what we call the remotes. They are no more in the statute book. Now, what his name is, tomorrow, once you become you enrolled as an advocate, and you will become an advocate. And there is no question of barrister, or there is no question of vakil, there is no question of attorney, and there is no question of pleader, all these things. So this is a advocate that this is the language that used it. Okay, in 2023 legislation. And next one is, another observation is, this is a little bit what we can functional and also normative. There is a normative change here. You please note down, accomplice shall be a competent witness. Accomplice shall be a competent witness against the accused person, and conviction is not illegal if it is proceeded upon the corroborative testimony. So, my dear friends, Mr. Krishna, please display the last this one. In the last one, the last but one sentence, you please read it. This is very important. This is, I agree. This is not the old wine, and it's the new wine and the new bottle. New wine and the new bottle. Accomplice shall be a competent witness.
Yes,
It is not illegal if it is proceeded upon corroborative evidence, corroborative testimony.
Previously uncorroborated. The word un was there.
Did not connect it here.
So therefore, what is
Link to that certificates.
138?
Sir, voice is
So
not clear, sir. Please.
133 previously and 138. Right. Okay. Really very. Sir, am I able to use
Yes, sir.
last point?
Well,
It.
So you are audible, sir. Please continue, sir.
Accomplice is a person who did crime and is a complete. But corroboration means compare. And compare whether he is giving true or not. Then only it is a good evidence. Previously, what it was uncorroborated, even without corroboration, and other miscellaneous provisions, we have 170 sections in the Bharatiya Sakshya Adhiniyam. 170 sections are there. Previously, 167 was there, and now 170 is there. So, enabling provision. With this few remarks and observations in the new legislation and compared with the previous legislations, I take this opportunity to, and the senior teachers who are all there sitting with you, and all, I'm very happy. Now it is open to you, my dear friends, that you can put questions, but very few questions I allow.
dear participants, you may ask if you have any questions.
Mr. Krishna, you take a lead.
Yes, sir.
Relevant to my presentation. Don't go to
Okay, sir.
the CRPs and CPC.
Yes,
Okay,
sir. Okay, sir.
your feedback and what we call appreciation, that's different, but if you want to.
Sir, there are some people who raised their hands. Sir, Rajesh was
Okay, then you take and you take. Please.
Hello. Sir, my name is Rajesh.
Please.
Yeah, sir,
Very
in the
good.
Evidence Act, you told the radical changes is happened it, and is a very welcoming decision of advocate. In many places, is they are calling the pleader, right?
Okay.
Really, it is a great thing, to those in the at least 2024, 2023, this act is enacted and changed a little bit advocate.
Okay.
Educate
Okay.
act is already 1960 there, but normally people are used to a pleader. If you go to the villages, always you say we want to go to the pleader, right? That votes the people. But
I
how we
appreciate.
are going to change it to an advocate? People.
Okay. So I appreciate your observation. So wisdom of foresters, this barristers, all these things were there. Now it is a made test that is everywhere that we have to use the word advocate. It's an advocate's act. Completely structural change. It's not a complete, but
Okay.
what we say Bharati, the liberalization, and what we can say globalization, So in those right, I appreciate your observation. Thank
Yeah,
you. Next,
thank you so much. Thank you very much.
right, good observation.
Sir, Reena Pillai has a question. She's asking, what significant change would you have wanted in the act which has not happened, sir?
Right, good. My dear friends, I am not praising the author of that is in 1872, Lord Stephen. He was a great scholar and great jurist. Every care he has taken, because every care he has taken to draft the legislation to meet the needs of the society. That's what we call litigation. So what the Indian Evidence Act is not a substantive law. It is not giving any rights or immunities or privileges. It's not giving. It is giving only how to bring evidences. I already told you, RAE is equal to P. First you take relevancy of facts. Next you take the examination of facts. Sorry, admissibility of facts. Then next one is examination of facts, and the result is proof. As far as the proof is concerned, Lord Stephen has taken a meticulous care. That is why Indian Evidence Act 1802 was considered as the grammar of the Indian law. The grammar of the Indian law is a grammar. So this is the observation. Many people have every care, contemplating the social needs. That is the language, how beautiful it is. You read section 11, previous section 7. So that's notwithstanding anything, what we can say, the previous facts not otherwise relevant become relevant. If they are inconsistent, highly probable, highly improbable, how beautiful that language is. Even today, that language is relevant. And if you change even one word, that what we call this, there is a possibility that it may be misinterpreted, it may be wrongly interpreted by the judges. That is why the professors who are set, what we call the members who are there, small, what we call structural or functional changes, but normative changes. This is my observation. There is no need of what we call such changes, radical changes to be done here. This is that's Act of 1870. I know that we made such. So there is no any provision to go to the court of law and say that is what we call is the constitution invalid, right? This is my
Thank you,
observation.
sir. Sir, Munmun Sunil Tyagi, you may ask your question.
Okay.
Munmun Sunil Tyagi. Anusuya,
Yeah. Tyagi, what is your?
you may ask your question.
Good evening, sir. I have a doubt regarding the section 133 and 138 of the comparison between 133 and 138. Please elaborate it, sir.
Previously, the word uncorroborated testimony was there.
So your voice is not audible properly.
Just to convert to the prosecution side. I hope it's coming and going as well. Okay. So the teacher is hello, it's not coming.
You're audible, sir, now.
It's okay.
Yes,
Now audible.
yes, sir, you're audible now.
You listen to me. Immediately accomplice to allow accomplice evidence. to make it relevant. Without matching, without taking the assistance of others, then that can be allowed. The status. This is to 55 previously, 5 to 55. Now the present is what is the scheme is previously 5 to 55. Now it is 3 to 50. The scheme is the same. But point is, previously, whatever the facts that you are bringing to the court of law, you have to establish the relevancy under any one of the provisions. Please understand. So 5 to 55, forget about 5. So 5 is introductory provision previously. So here is at least one of the provisions. From 6 to 55, you have to invoke one provision and satisfy the court. Sir, here under section 10, it is relevant. The conduct is relevant. Under section 11, that is called alibi is relevant. Like this, we have to establish. My dear friends, very carefully. Even if you establish that facts, ultimately, not to allow your evidence, it is the discretion of the judge. Why? So it does not mean that the judge will go against the law. For example, if you want to bring this, I'll tell you one example. In your college, in front of your college, an accident took place. And where in the college premises, there were what we call 100 students were there. 100 students were there. 100 students to the 2 PW, 3 PW are sufficient. One teacher, one student, and one employee. If these three people, the prosecution or the accused person, they plead, that's what we call the other party, because they want to win the case. Sir, don't. I want all 100 students to be examined. All 100 students are this relevant. There is no doubt in their seen. They are eyewitnesses. But only thing is, we have the limitations. That's what. How many number of evidences that we have to allow, and how many witnesses that we have to take it. So the same status even today. The discussion has not gone from the judge's hands, and it's nothing but section 5 to 55. Present. It is only the rules of the game, how you do it. The prosecution and the defense, the plaintiff and the defendants. These are the rules of the game. Within these rules that we have to play. And even if you play within the rules, discussion is there to the judge either to allow immediately. Then you go to an appeal. Sir, this is what we call it. Even if you are not, your evidence is not. Appellate court allow your appeal only when there is an interpretation of one of the provisions of the statute or interpretation of one of the provisions of the constitution. It is interpreted by the magistrate, whatever is interpreted by the district judge, they are the final, because we take note of that the judges are using their wisdom as far as the identification of or what we call interpretation of the facts are concerned. Right? No change. Status. Next. Okay.
Mahadevi.
They have given Indian names. Otherwise, as your good self told, everything remains the same.
And to make the people understand through this online mode, as you have suggested, we will have sessions in a physical mode, and we will invite you. And now only I request you to spare some time for us. And
sure.
As all the participants.
Sure, sir. Thank you. Thank you.
Yes, sir. Yes, sir. On behalf of the department and also on behalf of the Vijnaneshwara Pratisthana Trust, I wholeheartedly thank you, sir, for your valuable time with us. Dear participants, we tried to organize the webinar on these new criminal laws, and we invited a good resource persons. One is a judicial officer, one is a retired professor, and one is again faculty from NALSAR. And we will also organize these type of webinars in future also. So I request all of you to cooperate with us. And the Department of Law is a new one established in the year 2020, and we have organized different type of national level workshops, seminars, and also lecture series, FDFs. Many of the participants have benefited out of these programs, and I request all of you to be supportive for our programs in future also. Once again, for your interest and sparing time for this webinar series, I thank all the participants who have registered and joined and benefited out of these sessions. Thank you one and all for your valuable time, support and guidance. Thank you.
Thank you very much, sir.
Thank you so much.
Thank you, sir. Thank you.
Thank you, sir.
Thank you. Ragini, thank you. Thank you, sir. Thank you for your special
Thank you, sir.
interaction with
Thank you so much.
the resource person. Thank you for your wonderful.
Thank you, sir.
Yes, sir. Thank you, sir.
Thank you, Ragini madam. Excellent,
Thank you very much,
excellent
sir.
coordination, and thank you very much your patience also.
Thank you, Ragini
I
ma'am.
appreciate your really
Thank you, one and all. The program went very well. God bless all. God bless the team. Thank you very much.
Excellent.
Thank you so much.
All the 3 days very good. Thank you very much.
Excellent organizing team. Very good. I congratulate
Thank
all
you,
the
sir.
participants.
Thank you so much.
Very good. Thank you for your cooperation. God bless you all. Thank you.
Wonderful presentation, sir. Wonderful presentation. Thank you, sir.
Thank you all. Thank you.
Thank you, sir, for organizing this session.
Thank you, Lord.
Thank you, sir. Thank you.
Ma'am, I have a query. What about the certificates?
I have a question to Ragini madam. I have a question to Ragini madam. Madam, this last 2 days session I couldn't get it. I could not get it that feedback forms. Ma'am, kindly arrange.
So kindly message in the WhatsApp to the admins of the group. We will see your names and we will. I have seen, sir, you have actively participated in the webinar.
Yeah, last
We
3
will give it
sessions.
Just,
One second. One person at a time, please. Dear participants.
kindly just message in the WhatsApp. I will rectify it and give it to you. Don't worry, sir.
Please, ma'am. Please. Thank you very much. Thanks.
Thank you, sir. Thank you.
Thank you.
Dear participants who did not get the certificate, we have the attendance. If you have filled the feedback form, it will get to you automatically within few days. Don't worry about the certificates. We will make sure you get the certificates.
Okay, ma'am. Thank you, ma'am. Thank you very much. Ma'am, not received feedback form.
Hey, ma'am. Thank you. This is the first time I'm asking.
Yesterday's notes. Ma'am, feedback is not received. First 2 days.
Today's PDF, PPT and yesterday's documents we will share. After we take the permission from the resource person, we will share it in the WhatsApp group. Whatever the we have materials, we will share it.
Okay.
Ma'am, do we have different certificates for different sessions?
Certificates for all.
Yes, ma'am. There are 3 certificates for 3 sessions. Provided
Thank you, ma'am.
feedback form, you will get it.
Ma'am, you connected the session very brilliantly, ma'am. Thank you so much.
Thank you so much, sir.
Ma'am, I have already filled the feedback form for all the days, but we are not getting the certificates back.
Because
Same
we
with
have
me.
a daily limit of sending emails around 300. So if it crosses 300, we can't send because the certificate is going through mail automatically. So when it reaches the limit, it stops sending certificates or any mail. So because of that, you have not received even after filling the feedback form. Don't worry about it. If you have the attendance in, if you have filled the feedback form, it will be given to you. Don't worry about the certificate.
Request to
Ma'am, can you
kindly
please send
send
yesterday
the
feedback?
feedback. Request to kindly send the feedback form again, madam.
So dear participants, so whoever has these certificates issues and feedback form issues, please send a message to the number on WhatsApp instead of asking here, because we may not be remembering your names and all. So I'm sharing the WhatsApp number.
Yeah, that would be helpful. So you should ask our question to the admin of the group. Huh?
Okay, sir. Thank you very much.
Please
Thank you, sir, for
we
contacting
have noted it.
all
Thank you.
these
It's a good help to
wonderful
us. Yeah, yeah. It's a good help to us.
sir, please
Yeah.
give us some time, because to go through each message and revert back
Please,
takes some
please.
time.
Yeah, yeah.
Yes, sir,
Take
we
your own
can
time, sir.
understand.
So
Take your own time, sir. Thank you very
we
much.
will make sure, even if you message, we cross check the attendance.
I understood.
So, Sir Rajeshwara sir, there are some participants whom we can identify who are in the sessions on regular basis. So,
Yes, yes, yes.
thank you, sir.
Thank you. Thanks. Excellent. I wanted that keep it going on a good sessions like us. So it is a good for you for the research scholars. It is a very helpful sessions. Okay. Keep organizing like this only. Okay.
Sure, sir. Sure, sir.
I am the Professor Rajeshwara working in a NEA Global Law School, Bangalore.
Okay, sir.
I have 30 years of experience in the law faculty. Okay.
Okay, sir. Thank you very much, sir.
Thank you. Thank you very much. And both of you, excellent job you have done. Thank you.